Well, thanks for the question. The trend, as you described it, in my mind at least, it epitomizes the government's view of corruption and its view as to how and when corruption should be permissible, which, as we can tell from the statistics, is never. Now, over the last several years, the government's taken the view and made a priority of enforcing the US anti-corruption laws, in addition to encouraging other countries to enforce their version of the anti-corruption laws. Recently, you saw the UK come up with the Bribery Act, and you've seen recent enforcement actions in Germany, in Russia, in China, and the groundswell around anti-corruption is beginning to take hold. And in my opinion, I think that's a good thing. Well, it's an interesting question as to vagueness. I think that if you look at the last several years, a number of FCPA cases are oftentimes settled cases, and therefore you're getting the government's interpretation based on those settled cases. You also have the opinion release process where companies can go into the government and seek opinions as to whether or not a particular provision of the statute or a particular transaction or a particular region of the world it is likely to generate an FCPA enforcement action. Those kinds of avenues provide companies the opportunity to address the vagueness argument. Nevertheless, I would obviously like to see courts address some of these issues as to who is a foreign government official, when is a payment a facilitation payment, and when is it not a facilitation payment. What are the outer limits of the jurisdictional reach of the FCPA? And questions of that nature are ones that companies and the business community struggle with, and compliance officers struggle with, in attempting to craft a workable compliance program. What kinds of payments are violative under the FCPA? Does the fact that an email being sent from China to the US, is that enough to create jurisdiction? Those questions are still out there unanswered, at least from the business perspective. The government has a view as to what those answers are, but that's the government's view, and there's no counterbalance to that view. Well, it's an interesting question, because once you're there, you're there. But I think in the investigative process and the settlement process, I think companies need to find a good PR strategist. Lawyers lawyer, and then PRs types do that kind of work. I think you've got to get those two in the same room to manage the fallout of an investigation. My general counsel to clients is, you don't want bad news on the front page of the Wall Street Journal more times than you need it. Get the bad news out fast and deal with it, deal with the investigation, and attempt to fix whatever the problems are. The last place you obviously want to be is being a recidivist and coming back a second or a third time, because then the consequences could be more severe, both from a public relations standpoint and from a legal standpoint. But those would be the highlights.